Thank you for inviting me to speak at this event. I've been coming to India for several years. This is the first time I've had the opportunity to attend this great event. And I want to thank Dr. Agrawal, and I want to thank the Lakshmi Kumaran firm, in particular Malati Kumaran, Dr. Malati Kumaran, for her gracious invitation. And I've enjoyed myself very much here and look forward to continuing to build relationships with you. And I hope that the information I share with you today is useful. I've taken a more of a practical approach to this presentation and hope that the information I provide you will be useful in your practice and in considering what types of claim coverage that you'll be able to obtain, and that you'll be able to draft patent applications that will draft and prosecute patent applications that will survive in view of the many changes that are presently going on in the U.S. In many regards, and in particular with regard to drafting and prosecuting software patent applications. So I'll give you some examples of how things are changing. Our laws and standards are changing with regard to our statutes, our regulations, and our court cases. Now, Mr. Franco will be speaking a little bit later about specific Supreme Court cases, and I will just be mentioning a few of them, but not in detail. The detail will be provided later. With regard to our statutes, as many, if not all of you know, the American Invents Act was enacted in 2011, and it is now essentially in full effect. The AIA has touched most areas of patent practice, and I include a few highlights here, although this is not an exclusive list, but for our purposes today, these are the few that I will discuss. The U.S. has changed to a first inventor to file system, kind of. I'll touch on that a bit more. Our prior art definitions have changed under our Section 102. We now have a greater number of challenger opposition type challenges that can be made to patents and to patent applications. The regulations have changed to implement the statutory changes. These changes have been made essentially quite rapidly. And in view of the rapid nature of the implementation of these statutes, it's predicted that you will run into, predicted and likely that you're going to run into some things that don't quite make sense or don't necessarily work too well in practice. And the U.S. Patent and Trademark Office is well aware of that. So they've expressed an intent to make revisions as needed. We will just have to see how quickly they're able to make those revisions. The USPTO has also been conducting software partnership roundtable discussions. I include a listing of these here. One thing to note, though, the topics deal with functional elements included in software-related system claims, term definitions being provided in mandatory glossaries or suggested glossaries, a discussion about prior art searching and best practices with regard to that. And one thing to keep in mind is that when the USPTO goes to great effort to evaluate these different things and have discussions, and they have teams working on these types of issues, policy, regulatory, and examination guideline changes are quite likely because they've identified an issue and put considerable resources into addressing those issues. So the output of those programs are most likely to be regulatory examination or policy changes. At the same time, the output may end up being training for the examiners. And when examiners get training on different things, it's quite likely that you're going to see a significant surge in rejections or objections related to those topics that they're receiving training on. So if you want to see or predict where you're likely to see new types of rejections, look at this list of topics from the software roundtables. In particular, with regard to functional claiming, I've begun seeing different types of rejections related to functional claiming, functional elements in system claims. And when you get these rejections, they're going to look a little odd because you haven't seen them before. And they can look quite daunting because they're quite verbose to overcome. However, if you just take a little bit of time on the first one you get, you'll figure out real quickly how to work through them, confer with your U.S. counsel, and U.S. counsel will be able to give you good advice on how to move forward and alleviate any concerns that you might have. So the United States Supreme Court has also taken an increased interest in patent cases in recent years. Previously, the Supreme Court was somewhat reluctant to take patent cases, but in recent years it's become quite frequent. I include a listing here of several cases. As I mentioned earlier, some of these cases may be the subject of discussion later on. In addition, the Federal Circuit is always taking action with regard to patent cases. So there's this evolving jurisprudence around patents in general, and in particular with regard to software-related computer-implemented invention applications. So what do we do going forward? I'll be talking about what to do with the American Invents Act, subject matter eligibility, functional claiming, and surviving the different forms of post-grant challenge. So with regard to the American Invents Act, we have now become this first inventor to file type regime, well, kind of. You can establish your priority by being the first inventor to file, but there is also a provision that takes into account the one-year grace period that the U.S. has had for many years. If you happen to be the first to file, like I mentioned, you'll establish priority. However, if somebody else has made a public disclosure of your invention that's in your application that you filed first, well, they may have priority. So really, at the end of the day, we're not really first to file in a conventional sense. We're a first inventor to file or publish. However, there's many questions around what a publication will actually, what's the scope of protection that might provide you. Of course, we haven't had cases on this yet because it's a pretty new provision, having taken effect this past March. But really that comes down to what's the scope of the disclosure you made. Is that sufficient to be a priority, grant you priority with regard to the invention that you published about? In my mind, I believe that it is still best to file first before you disclose. That's a perfect world. In all practicality, though, in many large organizations, that doesn't always happen. So if there is a public disclosure, I highly recommend that you obtain copies of what's been disclosed, whether that be video or the documents that were disclosed or published, and put those in a safe and hold on to them in case you should need them at a later date. So considering that we're now kind of a first inventor to file jurisdiction, streamline your internal processes of disclosure review, your selection committee, reviewing these and selecting what to file on, and providing instructions to outside counsel to prepare and file applications for you. Streamline those processes, remove as much time from those processes as you can to aid your outside counsel in making the filings as quickly as possible. Also, mine for disclosures more frequently, and then begin the process. And I received this question just the other night, so what do we do when we have long-term projects? And the best answer is to have checkpoints in your processes or in your systems development life cycle to mine for patents. Maybe every 3 months or every 6 months or every year at different checkpoints in your systems development life cycle. Include a checkpoint for filing patent applications. And that might be a formal process, it might just be a phone call, whatever. But have that discussion because you want to be sure that you are able to file as early as possible if the invention is ripe for patenting. Also consider filing provisional patent applications. In such situations where you have long-term projects where you may not have reached a point where you're certain that the invention is ripe for patenting, maybe you can prepare and file a provisional patent application. And of course, in the United States, a provisional patent application may be as simple as a copy of a slide deck that has been prepared by the inventors. The best practice, however, would be to fully develop a patent application and file it, that it's fully enabling, and at least with regard to your novel and non-obvious elements. I already mentioned the risk of relying on public disclosures. In view of dealing with subject matter eligibility now, in view of the evolving standards, when you're preparing patent applications, we want to describe your embodiments in various forms, whether they be systems, methods, large systems, discrete devices, and so on, and describe your invention with strong system embodiments, with strong methods tied to various hardware components, and include claims of varied subject matter classes. With regard to functional claiming, under current U.S. software patent practice, different claim types, of course, can be utilized to cover software inventions, as I've generally mentioned thus far. Of course, you can use method claims, computer-readable medium claims, or Beauregard claims, systems claims, and means plus function claims. As mentioned earlier, the USPTO conducted roundtables in San Jose and New York with regard to functional elements and software-related claims. The issue is that system claims are generally intended to provide coverage to what a system is rather than what a system does. Functional elements and system claims have been asserted to broaden coverage of system claims, as the functional language is typically added to somewhat generic components, such as a general purpose computer or processor, to breathe life into that, to broaden what actually that processor is or does. So it's been asserted that such functional elements, rather than being read broadly, should instead be construed under Section 112F, which was previously 112 paragraph 6, as means plus function claims. Now, that's an issue because means plus function claims provide relatively narrow coverage. In the Donaldson case in 1994, means plus function claims were limited to the structural elements described in the specification, which, as you're probably aware, that's contrary to most jurisdictions. The means plus function claims in the U.S. are actually quite narrow. So with this risk in mind that your functional language may result in your claim elements being construed as means plus function elements, which are quite narrow, that's part of the reason why I'm saying ensure that you describe your system and your methods in great detail, tie the methods and the systems to various forms of hardware, because the claim is going to need some hard element. An algorithm in some cases has been considered to be a sufficient means, but you do need some form of a means in your, described in your specification to fully breathe life into your means plus function claim. And if your description is limited to maybe just one embodiment, your claim is going to be considerably narrow. This is also a unique challenge to software patents because previously the attacks have been with regard to Section 101 as far as subject matter eligibility. So this new attack on software patents is with regard to claim scope, and the idea is that if software patents are the problem, but their scope is narrower, the problem is narrower or smaller. So the risk of relying on a means plus function claims, it's greater than just narrowed claim scope. A major concern is that if your description does not breathe enough life into that means plus function element, or maybe no life at all, if all you have is the functional language in your application or in your specification without any structure or robust algorithm, it's possible that the specification will be found deficient for either clarity under 112A or for lack of enablement, clarity under 112B or lacking enablement for the invention under 112A. So if you lose a functional element under 112A or B, it's quite possible your entire claim will be lost. if that is the element that provides your novelty, all of a sudden that claim, if that element provides your novelty, you're certainly in trouble. But if the claim is deficient under 112A or B, the entire claim may be lost. And if that's an independent claim, all the dependent claims therefrom can also be lost. So the risk can be quite great if you end up with these issues with a system element being construed as a means plus function element. So in view of the current discussion and debate regarding functional elements and the rejections that are starting to appear with regard to system claims from the USPTO, describe many embodiments that are tied to both structural elements and clearly described algorithms, and use figures to illustrate your functional elements. When functional language isn't needed to support the novelty of the language or of the claim, consider omitting it entirely. If you don't need the functional language to get your claim allowed, either move it to a dependent claim or just remove it entirely. It would be essentially extraneous language. With regard to post-grant challenge, previously we had our re-exam, both inter-parties and ex-party re-exam, but now we have a greater number and different types of post-grant review. So with that in mind, expect a greater number of challenges to your pending patent applications and issued patents, and respond quickly upon receipt of notice regarding any such proceedings, as the dates for response can be quite short and are generally non-extendable. So contact your U.S. counsel promptly, and if litigation is a possibility, whether you're planning to assert a claim, or if you think somebody else is likely to sue you, ensure early review of your own options regarding initiating re-exam or the different post-grant challenge options. Also, when your budgets to file patents are limited, but the competition is filing many patents, consider challenging patents prior to their issuance. There's a narrow window within which you can challenge published applications, and there's some risks in doing so, so you want to have a thorough discussion on the topic. But if you don't have any patents, and if these patents would issue, or these applications would issue as patents, consider challenging the patents. You don't necessarily need to prevent the patents from issuing, but if you can submit prior art to the patent office, and those submissions are limited to 10 references, if you can submit references to kind of steer the applications away from the subject matter that your company is interested in, or maybe practicing, or you can steer the patents away from becoming an issue for your company. I kind of consider that to be like competitive portfolio shaping, and it may be a better use of your resources than filing a lot of patent applications. Maybe your company doesn't believe in filing patent applications, or maybe they can't afford it. Many reasons why you may not file, so consider pre-grant challenges. So with post-grant challenge, we need to consider what it means to kind of win. So from a petitioner's perspective, the requester of post-grant procedure, you may win in generally two ways: by eliminating a patent, or if this patent is at risk of being asserted against you, or has been asserted against you, if you are able to change the scope of claims in the application, the scope of the claims that are asserted against you or may be asserted against you, you will likely remove past damages. So if you've been infringing this patent for 5 years, but you're able to change the scope of the claims that can be asserted against you or are asserted, you can likely remove those past 5 years worth of damages. So this can be, even though the patent may survive, you can significantly mitigate the risk from patent litigation through use of these various post-grant procedures. So if you're the patent holder, if you end up in a post-grant procedure, you want to maintain your patent without any change in scope for it to be considered a win. So, tips to proactively survive post-grant challenge when drafting and prosecuting applications. Describe your embodiments with great detail and use well-defined terms to ensure you have adequate support for the claimed embodiments, and to support amendments during prosecution, and the thorough descriptions and term definitions help you ensure that you won't have unreasonable term and claim construction in litigation. Also, this shouldn't be any surprise for you in view of U.S. practice. Ensure that the best art that you are aware of or should be aware of is cited during prosecution according to proper IDS practice. So I believe with the different challenges that you may be faced with in post-grant practice, and many software patents have not been doing too well in view of recent post-grant decisions, there's an incentive to search the prior art. Get a good picture of what's actually in the prior art. I know many companies don't do prior art searching, but in view of post-grant practice, I believe that you will be well served by at least a minimal patent search. Also, keep in mind that anybody can get an invalid patent allowed. It happens. So just because an examiner is willing to allow your claims, don't trust it. Give the claims a look yourself. Take a look back. Maybe ask one of your colleagues who hasn't been working on the case and has the tunnel vision that you get, where you're only looking within the four corners of the document. You're not really looking at the full picture. Make sure your claim breadth is reasonable. Also, ensure meaningful dependent claims, ensuring that there's a tapering of claim coverage from the broadest independent claim to the narrow dependent claims. Think of it as a funnel. Your broad independent claim is at the top, ready to enter the funnel, and as it flows through the funnel, the dependent claims continue to get narrower. Now, where you run into problems in post-grant practice or in a litigation context that involves post-grant practice is where, rather than having a funnel with smooth sides, it's kind of jagged. And if you miss one of those jags, you provide a window in which somebody may escape infringement. If you lose your independent claim in re-exam, and then your dependent claim is just a bit too narrow because it takes a jag in on the side, that's where your adversary, where your defendant in patent litigation is going to want to sit. So they're going to take a look at your claims, see where those jags are. They don't need to eliminate every claim necessarily. They only need to eliminate maybe that broadest independent claim because your dependent claim is just a little too narrow. So take a look at your claim breadth and don't make big leaps. Don't go from a really broad claim to a really narrow claim because you provide a window through which your defendant may just jump through and avoid any possible liability for infringement. So keep that funnel analogy in mind. So that's what I have today. My contact information is on here. If you have any questions, feel free to contact me. And I'm very willing to answer any of your questions or provide you a copy of my slide deck. And I apologize, I won't be available for questions immediately after the program as I need to leave to catch a flight. But I have very much enjoyed this conference, enjoyed meeting many of you, and I look forward to an opportunity to meet you all again. Thank you.